Hello everyone. Thank you for joining us this evening for this presentation, which we have called You Can't Handle the Truth, or Can You? It's mostly an ethics talk with a little bit about some tips for preparing evidence thrown in. My name's Shana Clement. I'm one of the barristers at Greenway. I've been here since the floor started in 2016. And I'm co-presenting with Holly Lamb, who is a reader who's just started on the floor late last year. Holly was admitted to practice as a lawyer in 2010. She was president of the Women Lawyers Association from 2016 to 2018. She most recently worked at AMP Capital from 2019 before she came to the bar. At AMP Capital, she was one of two specialist in-house litigators who dealt with the litigation for their infrastructure, real estate and financial products portfolios. She completed the ARETA Advanced Certification in 2020. She sat on the Law Council's Equal Opportunity Committee in 2022 and she was called to the bar in 2023. Holly's got a very varied practice. She does commercial litigation, insolvency, building and construction, property, equity, wills and estates, whatever comes across her desk. So thank you again for joining us. We might take questions at the end unless you have a question that you're absolutely burning to ask during the presentation. We'll have some questions online as well at the end. And I will hand over to Holly to kick off. Let me pass it out.
Hello, welcome to our amazing ethics seminar tonight. We're going to cover quite a lot of topics. It's going to be a packed hour, hopefully fun as we go through some colourful stories and examples of how things can go terribly wrong. The name of our seminar is obviously You Can't Handle the Truth, or Can You? And we'll cover your fundamental duties, your duties to the court, proof before pleadings, proof, controlling the evidence, integrity of evidence, pleading and proving fraud, where the solicitor must not be a material witness, and what do you do if you find out that your client has lied. Starting with a bit of scary stuff, we'll go into unsatisfactory professional conduct, which is covered by section 296 of the Legal Profession Uniform Law. As you know, unsatisfactory professional conduct includes conduct of a lawyer occurring in connection with the practice of law that falls short of the standard of competence and diligence that a member of the public is entitled to expect of a reasonably competent lawyer. There is that expectation in society that once you are a lawyer, you are all at the bare minimum competent. Like there is no difference in that starting point. So examples of UPC include abuse of counsel. So in the case of De Severo and the New South Wales Bar Association, the barrister in that case decided to start abusing everyone. The principle that comes from that is essentially, is there a reasonable basis for you to put that submission forward, and will that submission cause offence when it's put? Like, is it bound to cause offence? So if yes, then there is a chance that it is UPC or professional misconduct. There are some times when you may develop a opinion of your client that may not be favourable, and in that case, in the case of Glisson, there was that situation where a barrister was convinced that his client was dodgy, for lack of a better word, and ended up pressing him to accept a settlement that was not, I guess, that great with his neighbour. So it is considered UPC to deprive your client of free choice. You advise, but you can't actually make the decision for them or have them or force them into a decision that you think is appropriate. Turning up to court drunk, that should be a no-brainer, but in the case of Thomas, that did in fact happen. And then things like double booking. So this is more for barristers, I suppose, than solicitors. In circumstances where, for instance, a barrister might be briefed to appear in a matter and it's not that sexy and exciting, and then they do get something else that is sexy and exciting, there is a temptation for the barrister to obviously drop that first matter and go with the second one, that is not possible unless the solicitor is told in advance and consents to that course of action. Professional misconduct is covered by section 297 of the LPUL, and that includes UPC, where the conduct involves a substantial or consistent failure to reach or maintain a reasonable standard of competence and diligence, and conduct of a lawyer, whether occurring in connection with the practice of law or occurring otherwise than in connection with the practice of law, that would, if established, justify a finding that the lawyer is not a fit and proper person to engage in legal practice. So professional misconduct, obviously a step up from UPC. Examples of it include showing disregard for the law. In the New South Wales Bar Association and Bryson, a barrister had become a little bit paranoid about his safety and went drinking at a King's Cross pub with guns on his body. And he happened to have, I think it was 3 pistols, 2 of them which were discovered by an undercover police officer standing next to him at the urinal. And it was sort of like vigilante justice was seen as not on from a lawyer. Preferring your own interests to a client. In the case of New South Wales Bar Association and Howan, Howan was an employee of Qantas who had been unfairly dismissed. The time frame in which to bring an application was quite short, and Howan missed that deadline, and instead of admitting that in court, blamed it on his client. Intentional deception to secure a better settlement. The duty of candour extends to settlement negotiations. Parties should expect honesty when engaging in settlement negotiations, as that promotes confidence in that settlement process. In the case of the Law Society Legal Services Commissioner and Mullins, Mullins was negotiating a settlement for his client with an insurer. And during the course of negotiations, it turned out that Mullins actually had cancer, which would substantially reduce the payout. Mullins decided not to say anything about that to get a better settlement for his client. But again, it's still professional misconduct, even though he didn't, he wasn't necessarily doing it for his own benefit. Abusing court and opposing counsel with the object of intimidating them. This should be a no-brainer as well, that is professional misconduct. In the case of Klein, the barrister Klein was intimidating opposing counsel because he wanted him to stop acting for his client's ex-wife. Fraud in personal life. In the New South Wales Bar Association and Sahad, there was the issue of Telstra shares, and there was a cap on how many shares a person could acquire. And so Sahad went and basically made share applications in a number of different names so that he could surpass the cap. That was also viewed as professional misconduct. And taking steps to crystallise an opponent's error. In the case of Chamberlain and the Law Society of the ACT, the Chamberlain basically had an outstanding tax liability. The liability was actually $250,000, but in correspondence with the ATO put the decimal place in the wrong place. So instead of the tax liability being $250,000, he saw it on the notice of assessment as $25,000, which he knew to be incorrect. So he, on one hand, there was no obligation on him to actually correct that error, but what he did was he took extra steps, such as getting judgment entered for the amount of the $25,000 and also having a settlement deed put, so that even when the ATO realised the error, there was not much they could do about it. And so that was seen as being professional misconduct because he obviously used his legal capabilities to take further steps to basically thwart, I guess, the administration of justice in that case. It all comes down to whether or not you are a fit and proper person. And the considerations as to whether or not you are a fit and proper person are the same as when you were first admitted. These are largely, it's obviously set out in the LPUL and also in the Legal Profession Uniform General Rules in Rule 13, including considerations such as good fame and character, insolvency, prior convictions, whether you've engaged in legal practice when you weren't permitted to or in breach of conditions, and your ability to carry out satisfactorily the inherent requirements of practice as an Australian legal practitioner. In Prothonotary of New South Wales Supreme Court and P, the situation was a lawyer who had been a long-time drug addict brought in drugs from Argentina on behalf of her boyfriend. The test was basically in terms of whether or not you're a fit and proper person. The test is that whether you were a fit and proper person at the time of the application, not when you actually committed the offence. So by the time her application came up for whether or not she would be struck off the roll, she'd already not been practicing for a significant period of time, and she also was no longer addicted to drugs. So that was sort of seen as she's not a terribly, not permanently a not fit and proper person. The decision also defined that fame is what people think of you, whereas character is what you actually are. So hence the difference between the good fame and character. So in the barrister's rules, these are the fundamental principles which reflect all of these duties, and our ethical obligations are largely set out in Rule 4, which is that the barrister's rules are made in the belief that barristers owe their paramount duty to the administration of justice, must maintain high standards of professional conduct, as specialist advocates in the administration of justice, must act honestly, fairly, skillfully, bravely, and with competence and diligence. And they owe duties to the courts, to their clients, and to their barrister and solicitor colleagues. Barristers should exercise their forensic judgments and give their advice independently and for the proper administration of justice, notwithstanding any contrary desires of their clients. And the provision of advocates for those who need legal representation is better secured if there is a bar whose members must accept briefs to appear regardless of their personal beliefs, must not refuse briefs except on proper professional grounds, and compete as specialist advocates with each other and with other legal practitioners as widely and often as possible. These are enshrined in a number of key rules, the first of which is Rule 23, which is the duty to the court. So a barrister has an overriding duty to the court to act with independence and in the interest of the administration of justice. Rule 42 then continues the point about independence, in that a barrister must not act as the mere mouthpiece of the client or of the instructing solicitor, and must exercise the forensic judgments called for during the case independently, after the appropriate consideration of the client's and the instructing solicitor's wishes where practicable. That follows on to Rule 43, which is the duty to the court, where a barrister does not breach their duty to the client and will not have failed to give proper consideration to the client's or the instructing solicitor's wishes simply by choosing, contrary to those wishes, to exercise the forensic judgments called for during the case, so as to confine any hearing to those issues which the barrister believes to be the real issues, present the client's case as quickly and simply as may be consistent with its robust advancement, or inform the court of any persuasive authority against the client's case. The short point, obviously, is that a barrister is not just a gun for hire. You are supposed to be independent and exercise your forensic judgment. Rule 58 continues with saying that a barrister must seek to ensure that work which the barrister is briefed to do in relation to a case is done so as to confine the case to identified issues which are genuinely in dispute, have the case ready to be heard as soon as possible, present the identified issues as succinctly and clearly as possible, limiting evidence, including cross-examination, to that which is reasonably necessary to advance and protect the client's interests which are at stake in the case, and to occupy as short a time in court as is reasonably necessary. In Giannarelli and Rafe, Chief Justice Mason put it this way: a barrister's duty to the court epitomizes the fact that the course of litigation depends on the exercise by counsel of an independent discretion or judgment in the conduct and management of a case, in which he or she has an eye not only to his client's success, but also to the speedy and effective administration of justice. In selecting and limiting the number of witnesses to be called, in deciding what questions will be asked in cross-examination, what topics will be covered in address, and what points of law will be raised, counsel raises an independent judgment so that the time of the court is not taken up unnecessarily, notwithstanding that the client may wish to chase every rabbit down its burrow. The administration of justice in our adversarial system depends in very large measure on the faithful exercise by barristers of this independent judgment in the conduct and management of the case. I would argue that that's also a benefit of the bar to solicitors. Obviously, as solicitors, you can get quite close to your clients and strongly believe in their cause. You've spent for a long time with them. Having a barrister come in is actually a really good. The value, I think, of a barrister is the fact that they are a step removed. You do get that objective opinion, and you can use the barristers to tell your clients the things that you don't want to say and like the things that they don't want to hear. So, and that is part of our ethical duty. The barristers' rules are replicated in the solicitors' rules as well. So it's not, although, you know, if you are a solicitor, you may be wondering why I'm going on about the bar rules, but they are actually largely the same as what's in the solicitors' rules as well. And Rule 3 of the Solicitors' Conduct Rules sets it out as well, that a solicitor's duty to the court and the administration of justice is paramount and prevails to the extent of inconsistency with any other duty. A solicitor must also act in the best interest of a client in any matter in which the solicitor represents the client, be honest and courteous in all dealings in the course of legal practice, deliver legal services competently, diligently, and as promptly as reasonably possible, avoid any compromise to their integrity and professional independence, and this should go without saying, as we are all lawyers, to comply with these rules and the law. On the topic of courtesy, I bring to you the case of Griffin and the Council of the Law Society of New South Wales. In the middle of 2014, Justice Foster dismissed an application for an extension of time to file proceedings under the Administrative Decisions Judicial Review Act, which challenged decisions of the Commission. The next day, the solicitor, the unsuccessful party, emailed His Honour with the following. Justice Foster, as solicitor for the applicant in this matter, I have serious concerns about your conduct and decision in this matter. These are, there's a long list of which I'll just pick out a few. To give you an idea of the long list, item 13 is about 22 lines long and comprises of one sentence. So we're in for a ride. So the first point that this solicitor took issue with was the somewhat immature and inappropriate comments you made to me at the first directions hearing when you responded to an innocent reference to yourself by me as registrar suggests that your displeasure in being referred to in that way may have impacted upon your ability to exercise the degree of objectivity required of an officer in your position in determining this matter. Point 2. The interest in identifying me as solicitor for the applicant on the judgment, contrary to usual convention, indicates you may have acted with some vindictiveness in regard to my client and myself in response to my innocent reference to you as registrar at the first directions hearing. Your own and your associates' obvious familiarity with counsel for the respondent at the hearing, the fact that counsel for the respondent had a copy of the decision when he arrived at court, the unusual, impermissible and ambiguous award of costs incidental to the application to the respondent, whatever that may entail. Those last three also highlight the need for their, not only for the court to be impartial, to actually be impartial and free of bias, but also to be perceived to be the same. This is from this complaint is being raised by a solicitor who really should know better. And although, I mean, to me, it's interesting that a solicitor would bring this point up, because then raises the question of, well, what would an ordinary member of the public also see? Like in this case, obviously the solicitor is clearly out of line, but I do think that as legal practitioners, we need to be on guard against any perception of bias, and that there is a lack of impartiality, and that also feeds into obviously the bar rules, whereby practitioners are not to sort of be seen as being too familiar or personal friends, for example, of the bench. The solicitor continued on to complain about the unusual attendance by counsel at court to accept the judgment on behalf of the respondent, together with the solicitor of the respondent, and then hence the giving rise to the inference or perception that the respondent was aware of your decision before it was handed down, and hence that you and or your associate had some disallowable communications with the respondent and his representatives relating to this matter before the judgment was handed down that may have impacted upon your ability to act objectively in deciding this matter. On that point, I should also, I suppose, raise the fact that all communications to the court should copy in the other side, or preferably be made with the consent of the other side. We do often see correspondence where only one party has written to the court and has not actually let the other side know that they were going to do that or that they had done that, and that is a bit of a problem. The solicitor has some unusual complaints, including the failure to sign the reasons indicating that the judgment may have been made by your associate and not by you at all. There is also here, and now I'm just being petty, at point 11, where he decides to say, your refusal to allow the applicant the opportunity to amend what is only a draft application, as is only required by the rules and as required of such applications. So he continues on in this vein. He then gets to the remedies that he wants, and so he says, on that basis, notwithstanding that I consider that our client has grounds to appeal your decision, and that I consider that your conduct in this matter is questionable, and further, that the Australian public and democratic values require and deserve a higher standard of decision-making in regard to reviewing decisions of political officers and their agents than that evinced by your reasons, I consider that many of the points raised above indicate that your decision was likely made without good faith and with bias. On that basis, in reliance upon Rule 39.04(1), I consider that I should extend you the courtesy of varying your judgment before it is entered and before I submit it to appeal. Hence, I request that you consider varying your judgment, the orders and reasons before they are entered and before an application for appeal is made. He then went on, as you can tell, this was quite a long letter. He then was not satisfied with just complaining about what happened or about those matters. He then went and said that one of the orders that he was seeking, or one of the remedies he was seeking, was for removal of the words and other errors of expression at paragraph 21, as no such thing exists, given that whether something is an error of expression is a subjective opinion, and given that you are not an expert in the English language and not qualified to make such a comment or give such an opinion, while I have an honours degree with distinction.
Delicious.
Including honours cognates in English. I consider that this comment is clearly vindictive and naive and contrary to current theory regarding what non-erroneous expression is or what correct expression should be. Neither you nor your associate are qualified to make this comment, and it displays infant school and pedantic understanding of what language actually is. I also consider this comment evinces a puerile and petty intention to belittle a person, which is an attitude that has no place in the administration of justice. And so he then gives the court 7 days to respond, notwithstanding any embarrassment it may cause to you and your associate, and I will need to seek other legitimate methods of addressing what I consider to be your vindictive, unreasonable, and unnecessary expressions of opinion. So what do you think? Is that professional misconduct?
We've all wanted to do it.
Was he struck off?
He was reprimanded.
Right.
It was, yes, a finding of professional misconduct was made. He was reprimanded and ordered to complete and pass a legal ethics course. And he appealed. And this was basically the appeal decision. So. Rule 5 also says that a solicitor must not engage in conduct in the course of legal practice or otherwise, which demonstrates that the solicitor is not a fit and proper person to practice law, or is likely to a material degree to be prejudicial to or diminish the public confidence in the administration of justice or bring the profession into disrepute. The question of whether someone is or not a fit and proper person is a bit interesting. So this is I think it's fair to say that the legal profession is it's an honesty profession. Like, you can get a lot away with a lot of things, but generally speaking, anything related to fraud, dishonesty, misleading, deceptive conduct, like, that's the type of stuff that will really get you. And there's things that are, you know, easy to get into as well. In the case of Zeems, it was held that Zeems was at a pub, and he'd had a few drinks, and he saw there was a big sailor who was harassing a young woman on his way out, and so he went and got into a bit of a scuffle with this other person. He was then concussed because his head was bashed against the wall of the pub. And when the police and the paramedics came, they told him to just stay put and, they'll take him to his accommodation. He waited a while and then started driving to his accommodation. He then hit and killed a motorcyclist on his way to where he was staying. So he was initially it was initially found that, obviously he was jailed for manslaughter. And then afterwards he basically appealed on the basis that actually he was concussed as opposed to he was drunk. It was at the time when they convicted him, they thought that he was driving erratically because he was drunk. And when the full circumstances of the situation were revealed, then it was sort of held, actually, maybe it could have been concussion. In that instance, the court basically held that conviction and imprisonment doesn't necessarily mean that a person is not fit and proper to practice. This leads back to all of those movies and books that you've ever seen where someone goes to jail and then they become a lawyer upon exiting jail. So depends on your offence. So personal misconduct, the court will look to conduct that gave rise to the conviction, and personal misconduct may be grounds for discipline or disbarring, as it may demonstrate that a practitioner is not a proper person, but it's distinct from professional misconduct. And in this case, Zeems was held to be a fit and proper person. So he was suspended for the period that he was in jail, since he obviously could not do appearances, but he was otherwise, it was fine. He wasn't struck off and he was able to recommence practice upon leaving jail. In the case of a solicitor, this is a bit of a controversial one, where the proposition is that professional misconduct must be connected to professional practice. In this case, the solicitor was apparently under severe stress, and he basically molested his girlfriend's young children, and that wasn't enough for him to be struck off. What actually happened was, while he was being investigated by the Bar Association, it turned out that some new charges had been brought against him as well, and he hadn't disclosed those new charges. So he was actually pinged for failing to comply, well, basically to failing to uphold his duty of candour as opposed to what he actually did, which is a bit, I don't know, like I find that I'm very uncomfortable with that case. Then there's also the case of Cummins, where the profession must maintain the highest standards of integrity, and conduct outside practice may amount to professional misconduct if the conduct is closely connected with practice. In this case, Cummins was a barrister who managed to practice for like 40 years without paying any tax. Yes, and he was the financial controller of at least 7 different companies, but yes. So in that case,
very bankrupt memory.
Yes. So there was a complete disregard of his legal and civic obligations, and he was removed from the role, considering he was someone who was deriving an income from the practice of law, and paying your tax is kind of a bit of a basic requirement. Rule 19 deals with where a solicitor must not deceive or knowingly or recklessly mislead the court. Solicitor must take all necessary steps to correct any misleading statement made by the solicitor to a court as soon as possible after the solicitor becomes aware that the statement was misleading, and will not have made a misleading statement to a court simply by failing to correct an error in a statement made to the court by the opponent or any other person. The case of Costigan is where the barrister improperly used trust funds, and he failed to notify the Bar Association when he received a creditor's petition. He failed to provide written statements showing why he was still fit and proper, why he was still a fit and proper person to hold a practicing certificate when he was bankrupt. and he also failed to notify the Bar Association of other convictions. In that case, it was held that his conduct would reasonably be regarded as disgraceful or dishonourable by his peers. We are an honourable profession. So he would not be regarded as a person of good fame and character for the purpose of admission, both because of the nature of his conduct in misleading courts and engaging in legal practice, and holding himself out to be a barrister when he did not have a current practicing certificate, and also improper dealing with client monies advanced. So in that case, he was struck off, and a finding of professional misconduct was found. We're an adversarial profession, and obviously everyone wants to win. There are situations, though, when your duty to the court very clearly overrides, I suppose, your duty to the client. This is in the case of ex parte applications. Rule 19.4 sets out that a solicitor seeking any interlocutory relief in an ex parte application must disclose to the court all factual or legal matters which are within the solicitor's knowledge, are not protected by legal professional privilege, and the solicitor has reasonable grounds to believe would support an argument against granting the relief or limiting its terms adversely to the client. This one is really important because obviously in an ex parte application, only one party is showing up, only one party is presenting the case, and the court relies on you to paint the full picture and let them know exactly what the situation is, not just your side of the story. Rule 19.5 continues on to say that a solicitor who has knowledge or matters which are within Rule 19.4, so those things which are privileged, must seek instructions for the waiver of legal professional privilege if the matters protected by that privilege, so as to permit the solicitor to disclose. If the client does not waive the privilege as sought, then you have to inform the court that the solicitor can't assure the court that all matters that should have been disclosed have been disclosed, which is slightly different to the barrister's rules, which basically say that a barrister just can't appear in that situation. And obviously you must tell your client of their responsibility to authorise such disclosure and the consequences of not doing so, i.e. that you either can't appear or that you're going to have to tell the court that actually it can't tell you the full story, which is a pretty bad look. In Thomas and S&P International, this is a matter which is like a gift that keeps giving. It was an urgent ex parte freezing order application, and it was held subsequently that freezing order had been obtained improperly. In this situation, there was a failure to provide full and frank disclosure. The applicant didn't seek an undertaking from the other party that the proceeds of a property sale would not actually be removed from the jurisdiction, and also failed to give the other party notice of the application. In this case, the applicant submitted to the court that the freezing order was required because the defendants were taking no steps to prepare for trial, and that the evidence showed a dishonest intention to dispose of their assets so that they could avoid meeting any judgment. This is despite knowing that the defendants were in fact preparing to meet the case. They had engaged counsel and solicitors, spent significant time and money on preparing it. There were lots of interlocutory stoushes, and there was no basis whatsoever to suggest that there was any dishonest intent to dispose of the assets. In that situation, the freezing order was initially ordered, and then it came to light that actually the full picture had not been provided to the court. The parties went back, and on that occasion, obviously, the defendants sought to have that freezing order removed. Instead of owning up to the lack of full and frank disclosure, the applicant instead took the position that they weren't going to press for the maintenance of the freezing order that had been made, but they would just seek a new one on the same basis. In that case, indemnity costs were ordered against the applicant. And now I'll hand you to Shana for proof before pleadings.
And of course we all know that you don't go and make another one of the same interlocutory application because Bramord and Honeysett says you can't do that. Anyway, we'll come back to Thomas and SMP shortly on another issue. So, proof before pleadings. So I'm going to talk a bit about proving cases and pleading cases, things you need to do, marshalling the documents is of course an important first step. A good rule is to marshal the documents first, prepare your chronology based on the documents, and then set out the objectively provable facts, and prepare a detailed proof of evidence before you plead your case. The proof before pleadings rule is one that was drummed into me when I was working for a judge in the Supreme Court. And I remember on one occasion, about a year after I'd worked for him, I came up to Chambers to have a chat about a case I'd been working on, which had settled, thankfully. And we had prepared the pleadings, we had a proof of evidence, but it wasn't an affidavit. And then when it came time to put on the evidence, we discovered that our witness couldn't come up to proof. And we said, well, but here's the statement that you agreed to before we did the pleadings. And he said, well, I can't swear an affidavit to that effect. And I was telling the judge this story, and he looked at me and he just went, what about proof before pleadings? He looked genuinely shocked, and I assured him that we had actually done that. But it was a great lesson for me in getting the witness to sign up to something before you actually sign off on the pleadings. Even if it's not an affidavit, get your proof of evidence and get them to sign it so that if at the end of the day they don't come up to proof, you can say, well, these are the facts that you gave us, this is what you instructed us, this is the basis on which we've pleaded your case. And that is particularly important when it's a case that turns substantially on a witness's version of events as opposed to just documents. So I'm sure we're all familiar with the case of Watson and Foxman. It's a great case where the Chief Judge in Common Law, which inadvertently says equity there, but McClellan was the Chief Judge in Common Law at the time, talked about the fallibility of human memory and the fact that people do forget things, they overlay things with their own, with the passage of time, they overlay memories by perceptions of self-interest, and it's not necessarily intentional. They're not intentionally lying about things often, it's just the way the human memory works. And that is why the courts say they are much happier to accept a version of events that is consistent with contemporaneous records. And His Honour said there that was a misleading and deceptive conduct case that turned substantially on a conversation or conversations. And His Honour said considerations of these kinds can pose serious difficulties of proof for a party relying on spoken words in the absence of some reliable contemporaneous record or other satisfactory corroboration. So bear in mind that if you can support it with a document, you should do that. We've all been in these situations with a witness or a client where you're trying to test their recollection of things or their version of events, and then they say things like, but you're meant to be on my side. Sometimes the allegations they want you to make are outlandish and you really do need to test them. That is often a good point to get counsel involved when you need someone to really test the allegations, because as Holly said, you get that objective third party who can step in and assess things and give the hard advice. It's always better that you test it in conference than that it's tested in the witness box for the first time. I'm sure many of us have been in that position where you're watching evidence being given and something comes out that perhaps could have been tested earlier by reference to a document. It's not fun. It's not a pleasant experience. Of course, sometimes the outlandish allegations are the ones we need to run. It doesn't matter how hard you test them, that's the client's story. And to a point, we're duty bound to run those cases. And I'll refer in a few minutes to to one matter in particular where there were some pretty outlandish allegations that had to be run because those were the instructions, and it made for some interesting reading at the end of the judgment. Now, proving a case, degrees of relevance. I like this little diagram because it often helps to work out sort of how relevant is this evidence that I'm putting into an affidavit. Where does it sit on the scale? Can I justify it? Is it persuasive enough to put it in? I won't read out the test for relevance of evidence, but it's pretty loose. There's a lot of things that can affect the probabilities of facts In the middle, we've got the direct evidence that proves your client's case. The next circle of relevance is the evidence that disproves the other side's case. And then after that, it's almost too small to read, evidence that affects the probabilities. So evidence that makes it more likely that your version is correct or makes it less likely their version is correct. And you sort of, on the fringes of that dark blue circle, you get to credibility evidence, and that, I mean, sometimes credibility can be right in the middle, of course, depends on what the case is, but credibility tends to be at the outer edge of that diagram. So the provenance of documents, sometimes you will need an affidavit to prove a document that it's authentic, where it came from. Sometimes the document can prove itself, and I'll get to that section in the next slide. The need to actually prove a document can be particularly so if the actual source of the document is fundamental to the case. The examples that I've given here are two judgments in the Origin matter, where the first of those involved a deed of trust, and the defendant, one of the defendants, said, "My mother signed this deed of trust, so she held on trust for me the shares in this family business, this company." And their whole case turned on whether or not the company was held on trust. And unhappily for them, although the signature looked quite all right, and it would have been difficult to prove that it wasn't the client's signature because of the array of different types of signatures that appeared on documents in the matter. In that case, the person said to have signed the trust deed, who was holding the shares on trust, had been travelling around the Northern Territory at the time, and she kept this handwritten diary of things like left Lake Marraboon, brackets, Fairburn Dam, close brackets, Emerald, 9:30 a.m. Stopped Emerald, took photo Big Etch, and went to RTA, brackets, boat licence. Left Emerald, 12 p.m, stopped Blackwater. There was a reference to the cost of a pie at the local pie shop. It was riveting reading. But in addition to that, she had phone records that showed where she was making calls from, and she had bank statements that showed that she'd been effecting transactions at those various places. So we had to look to documents to prove that there was no way she could have signed the deed, and the judge ultimately found that she did not execute the deed. And of course, those were all documents and things that the other side couldn't have got their hands on to test the evidence. Those were all things that could only have come out from the possession of my client or through subpoenas. Sometimes you can test things by reference to publicly available documents. I had a matter where there was a constructive trust claim, and it was said to, the constructive trust in respect of a property was said to arise from a particular conversation that had taken place at a particular house. It was, I was at Robert's house, Smith Street in Waverley. I was with mother-in-law. She said to me, the house will always be yours. I said, I'm going to borrow money to put a floor on up top, but I don't want to do that unless I'm ultimately going to end up with the property. And mother-in-law said, well, yes, of course, it's yours, it's for you and the kids. And the first time that evidence was tested, where she said she'd relied on that conversation at that particular property, which was a week before the signing of the facility documents to then put the extra story on the house. The way we tested that was to do title searches to see who owned the property they were said to have the conversation at. And the property had been sold 18 months before the conversation took place. And in addition to that, the person who was said to own the property had bought a property in Queensland at the same time he'd sold the house. And then Google Earth photos showed us that the property had been renovated by the people who bought it at that point. So there was just a stack of evidence that we could point to publicly available that showed there was no way the conversation took place. So when you're marshalling the evidence and putting things into chronological order, if there are those objective things you can look to actually test the evidence as you're putting it together, it can be case saving at the end of the day. That was a matter that settled shortly after the evidence of the transfer was put on. The other case, the other Origin case I was going to refer to, is a really good read if you feel like reading a ridiculous story. So it was the same case about the trust deed. and the defendants applied to reopen the case to adduce fresh evidence that they said they'd been given. And the evidence was statements that they said were inconsistent with the evidence that had been led by the plaintiffs in the trial. And so they applied to reopen. And they said that these documents had been obtained by one of the defendants walking down the street, and the guy he knew drove past him in a car and waved and then came back. And it wasn't clear whether he'd driven past and got out or whether he'd walked back, but he handed him an envelope of documents, the magical yellow envelope. And so this guy then went off to the country somewhere and came back with his envelope of yellow documents. Then he went to Sydney, and there was some guy whose surname he didn't remember standing outside someone's flat. And like these documents were passed from person to person until they got to the defendant. And it was a fantastic story. Unfortunately, the story changed about 6 times in the witness box. And Justice Young actually said, in my 28 years on the Supreme Court bench, these are some of the worst witnesses I've ever seen. He ended up finding that, in fact, the documents had been obtained by the defendants by ringing up Telstra and pretending to be my client, getting her password, hacking into her Hotmail account, and stealing the documents from a Hotmail account. So it was there were these two completely different competing narratives about how the documents had been obtained. But again, it's one of those cases where the person who is arguing the case for the people who have the documents has to put the case. And I felt sorry for him when he was watching his witnesses crumbling in the witness box. But it can be a difficult line to draw. Like, you can test your client's version, but if they tell you, no, this is what happened, sometimes you just have to put the case and see what happens. Unfortunately, if you haven't been able to test it by reference to objective facts, it can be a problem at the end of the day. All you can do is advise. So just going on to documents, some documents do prove themselves. So Section 58, there are inferences the court can draw from the documents. And there are 2 cases I've referred to there which say that, yes, you can draw inferences from the face of a document to confirm the authenticity of the document. You don't necessarily have to prove the authenticity of every document. Now, another duty. This is a common law duty. It arises from case law. The duty to curtail evidence. And it also flows from some of the rules that Holly's been talking about. You can see parts of the Solicitors' rules that give rise to the duty to curtail evidence. There is, of course, in New South Wales, Section 56 of the Civil Procedure Act, which is the parties and the practitioner's duty to assist the court to further the overriding purpose, which is the just, quick and cheap administration of justice. And of course, Solicitors Rule 4 says that solicitors must comply with the rules and the law. Well, Section 56 is a part of the law, obviously. And there is a fabulous case by Justice Pembroke, which is another part of the Thomas and SMP International series, where you can almost hear his honour sobbing in chambers at night as he writes this judgment. He's going through the question of the objections to evidence in an affidavit, and he says, after 3,000 paragraphs, I ceased. I could go no further. And his honour goes on to talk about the duties that practitioners have to curtail the evidence. We've all had those cases where you have a client who just wants to say a lot, and it can be really hard to manage that. It helps to be able to point to a judgment that says, I have this duty, and so I can't do this for you. You want to put on 80 pages of affidavit where 15 pages would suffice. I cannot do that for you. And that can be persuasive, and some clients won't be persuaded. I had a matter where, and I'm normally in favour of headings in affidavits, they're quite good for signposting, but I got one affidavit in a matter where the client had amended the affidavit substantially to add to it and put in their own headings. They included lies and deception, fraud by the plaintiff. Following all of those headings, there were really no facts. And we had to have that conversation of, all right, so evidence is what you saw, heard, said, or did. and get them back to the facts. And a lot of the assertions that they were trying to prove just couldn't be made out with facts. They were just assertions. So you do need to prevent having unfiltered outpourings going into evidence. I had a matter where the affidavit went from 20 pages when it was sent to the client for review to 80 pages for the conference the next day. It's difficult to manage, but you do have to manage it. And that was made very clear in Olsen and Olsen, where the judge said, no matter how determined a plaintiff may be to unburden himself of memories of real or imagined distant family events, his solicitors and counsel are duty-bound to restrain his enthusiasms. And that was a quote of the first instance judgment, and the Court of Appeal agreed with that. It was Justice White who agreed, and the other judges agreed with His Honour. Those are very helpful cases for those instances where you have a client who just wants to give everything, whether it's relevant or not. Now, some more solicitors' rules. I was going to hand over to Holly, but I note the time, as they say. So I might just flick through some of these solicitors' rules, which are about evidence. Need to be aware of these rules. Telling the truth, it's always important. Questioning and testing in conference the evidence, it's important. Conferring with witnesses together. I've been put in positions where the witnesses absolutely have to have this person with them in the room when you're talking through the evidence, settling the affidavit. It's an absolute no. And again, this is where the solicitors' rules really come in handy, because you can actually say, look, I'm duty bound to not do this. No, the answer is no. So always be aware that you can rely on that rule if you're getting that pressure from a witness. There are some exceptions to it, of course. If you're not just drafting the evidence and you're talking about some of those things in Rule 25.2, then you can confer with them. Fraud, you've got to prove it properly, you've got to plead it properly. I think we all know that, but there are some rules that apply specifically to fraud. And that question of what is fraud, the general rule of thumb is dishonesty. But unconscionability, for example, is a type of fraud. It's an equitable fraud. You have to plead enough facts that it is that the other side is able to properly understand the case. What is the thing that's been done that is wrong? These rules, 21.1, obviously you've got to have what you put has to be reasonably justified by the material. Don't abuse the privilege. You must have reasonable grounds to put things. Is it in a nutshell? You cannot allege a matter of fact unless you believe on reasonable grounds that the factual material available provides a proper basis to do so. It's particularly important for fraud. It has to be available material. You can rely on the opinions of an instructing solicitor. This is an interesting one. I'd seen this in the bar rules. As a solicitor, you can also regard the opinion of an instructing solicitor as a sufficient basis. It looks like someone's just copied and pasted the bar rule across to the solicitor's rules. So I've addressed in this slide briefly what fraud is. Again, it's dishonesty, but it's also equitable fraud. You have to plead it properly, you have to particularise it properly. Those are some authorities, but of course we've got the UCPR as well. Rule 14.1 tells us that it has to be pleaded specifically, and it has to be properly particularised as well. You could do a whole hour CPD on pleading and particularising fraud very easily, but we won't right now. And then finally, as this is only supposed to be an hour-long CPD, of course, you can't be a material witness in your client's case. And there are cases where a solicitor's affidavit is obviously necessary for things like security for costs. I've had people say, does this make me a material witness in my client's case? Not for things like that. Material witness is if you're giving evidence about the subject of the proceedings. So, for example, a great and very common example is the solicitor who drafted the will that's in dispute in a probate case. So material means they're actually giving evidence about the facts of the case as opposed to procedural matters. Although the line can blur there too, because sometimes those procedural matters do end up as the subject of proceedings. I will hand over to Holly for the delinquent or guilty clients, which we'll do quickly and then we can do questions.
Thank you. I'll be really quick. Delinquent or guilty clients, as much as we all know that our clients are wonderful and innocent and have done everything properly, on the rare occasion we do get clients where you would trust them as far as you would throw them. So, a solicitor who knows or who becomes aware that their client has lied in giving evidence, what do you do in that situation? The short answer, essentially, is you have to refuse to take part. Refuse to take any further part in the case unless the client authorises the solicitor to inform the court of the lie, the falsification or suppression, and must promptly inform the court of the lie, falsification or suppression upon the client authorising the solicitor to do so, but otherwise may not inform the court of the lie, falsification or suppression. So as a barrister, that's when you basically tell the court that you cannot continue appearing or acting in this matter for ethical reasons. You don't have to go any further than that, and the court will usually understand. Again, it's a pretty bad look. So first rule, whenever you do your client conferences, is tell the truth. You would rather, and I think that's something that should be stressed to your clients, that, you know, as their lawyer, you can argue or you can make, you know, a pretty decent argument about any set of facts. But the thing is that you actually need to know the facts. So it's incredibly unhelpful when your clients lie to you and you end up trying to sugarcoat things or allow them to sort of control you, when it has to be the other way around. Because the questions, it's usually that case of, you know, if something sounds a little bit fishy to you and a little bit implausible, someone's going to test your client on that. And if it's not you, then it's going to be the other side. And you would really, for all, you know, for you and your client, you would rather it happen in the safety of your conference room than in cross-examination. And we'll end with a fun case of the Bar Association and Punch, where there was essentially a robbery in Roselands, and the solicitor knew that his client was at the premises, but not only did he advance the argument that his client was actually at home in bed, he also helped him find witnesses to act as alibi evidence. So that obviously is a big no-no. Don't do that. And that's the end of our presentation, and we're happy to take questions.
Are there any questions online? No? Great. There are refreshments at the end too. All right. Well, thank you everyone for coming.